Que ça me dit... je bascule en canal français.
Good morning, committee members. Greetings to the delegation of the Government of Hong Kong Special Administrative Region, People's Republic of China, participating remotely from Hong Kong. Good morning to the members of the Permanent Mission of People's Republic of China here in the room in Geneva. This is meeting 3895. This meeting is devoted to the consideration of the fourth periodic report of Hong Kong, China. As you recall, on Friday, 8 July, the committee had to suspend the meeting earlier than expected due to technical issues of connectivity. I understand that the problem was on the Geneva side. My apologies to the delegation for such an inconvenience. I would like this to be reflected on the official summary records. I also understand that conference services have agreed to grant us additional 30 minutes during today's meeting on an exceptional basis. The committee highly appreciates such a facilitation of our meetings. Today's meeting will therefore last until 12:30 hours Geneva time. I now advise that we start with the delegation of Hong Kong, China, where we left off, to continue responding to questions raised by my colleagues on issues 10 to 19 of the list of issues last Friday. I suggest that the delegation have 20 minutes to finish its responses, which it had already started on Friday. And after that, we will continue directly with the third and last round of questions, namely questions regarding issues 20 to 27 of the list of issues. I will now give the floor to the head of delegation, Mr. Tsang Kwok-Wai. Over to you, sir, for the responses from Friday.
Morning, Madam Chairperson, and thank you for letting us to finish our responses. We'll try to keep it concise. So, Mrs. Liu, please continue.
Thank you, Madam Chairman and members. I will first continue to address the issues raised by Mr. Gomez regarding the designated judges. On the issue of designation of judges for hearing cases concerning offenses endangering national security by the chief executive under Article 44 of the National Security Law, on top of my explanation on Friday, I would like to supplement 3 points. 1. Whether designated judges exercise independent judicial power was actually raised as one of the grounds in an early habeas corpus application. In rejecting the ground, the court ruled that the chief executive does not assign or nominate any particular judge to hear any particular case. The question of which judge is assigned to hear any given case remains a matter for the judiciary and not the chief executive or the government. The court also stated that there is no proper or sufficient basis to contend that the chief executive or the government is in a position to interfere in matters that are directly and immediately relevant to the adjudicative function. While accepting that when discharging judicial functions, the judiciary must not only be independent, but must also be seen to be independent. And it was stressed that a judge is bound by the judicial oath taken by him upon his appointment, which requires him to discharge his judicial functions in full accordance with the law and without fear or favor. Point 2. Regarding para 2 of Article 44 of the National Security Law, which prohibits the designation of any person who has made statement or behaved in any manner endangering national security, the requirement is only natural in order to avoid any actual or reasonable apprehension of bias, thereby assuring the impartiality of the court in handling cases concerning offenses endangering national security. This requirement reflects a fundamental principle of the rule of law, that is, a judge is disqualified from sitting in a case where there is actual or apparent bias on his or her part. This should be stressed that removal from the list of designated judges does not affect one's tenure as a judge or judicial officer, which remains protected under the basic law. Point 3. Regarding the disclosure of information concerning designated judges, it is in the public interest that confidence relating to the designation of judges should be preserved and protected by law before the judges hear any cases concerning offense endangering national security. There have been threats of violence, including even death threats to designated judges who handle cases concerning offense endangering national security. We further note that there have been recent calls by foreign entities for the imposition of unilateral sanctions on designated judges, on which we condemn as a violation of the principle of non-intervention in international law. On the whole, we do not consider there to be an overriding public interest in the disclosure of detailed information regarding the designated judges. On bail arrangement for cases concerning offenses endangering national security, I have already explained to members on the first day of the hearing the operation of the arrangement, as well as factors affecting the duration between prosecution and the actual trial, and also the processing time from the first day of hearing to conclusion. I should add that in a recent case concerning the provision on bail, that is Article 42(2) of the National Security Law, the Court of Final Appeal of Hong Kong, Patrick pointed out the cardinal importance of safeguarding national security and preventing and suppressing acts endangering national security, which explains why Article 42(2) introduces more stringent conditions on the grant of bail in relation to such offenses. On the other hand, the Court of Final Appeal has held that Article 4 and Article 5 of the National Security Law, which expressly stipulate that human rights and freedoms and rule of law values are to be protected, and here too, in applying the National Security Law, provide the context in which the article must be construed and applied. As far as possible, the said article is to be given a meaning and effect compatible with human rights and freedoms and rule of law values. As such, the said article is not incompatible with any provision of the ICCPR as applied to Hong Kong. On the use of pre-national security law information as evidence, it should be pointed out that Article 39 of the National Security Law enshrines the principle of non-retrospectivity of criminal offense by providing that the law shall apply to acts committed after its entry into force. for the purpose of conviction and imposition of punishment. By virtue of this provision, a person cannot be convicted of a charge under the national security law on the basis of any act committed before the law comes into force. On the other hand, a person's acts before the law comes into force may be relevant for the court to understand the proper context that the act committed by the person after the national security law comes into force and his or her state at mind. The court actually has in fact held that although what a person did before the national security law comes into force cannot be in law form the subject matter of any charge, the person's worst conduct and before that are capable of forming the background, and therefore that will allow the court to interpret his or her state of mind inferred. Therefore, the use of evidence to such extent does not violate the principle of non-retrospectivity. On non-jury trial, Article 46 of the National Security Law stipulates that the Secretary of Justice may issue a certificate directing that the case be tried with a jury on the grounds, amongst others, the protection of state secrets, involvement of foreign factors in the case, and the protection of personal safety of jurors and their family members. However, the Secretary does not necessarily have to issue a certificate in the above circumstances. Each case is to be handled on a case-by-case basis. It should be pointed out that the provisions regarding jury system and the principle of criminal proceedings of basic law do not prohibit the HKSAR from making changes to the principles of existing jury system, so long as the changes are not fundamental and do not abolish the entire jury system. Neither basic law nor the ICCPR stipulate the defendants enjoy the right to jury trial in criminal proceedings. Article 46 of the National Security Law stipulates that where SJ has issued the said certificate, the case is to be tried in the course of first instance without a jury, but by a panel of 3 judges. Trial by a panel of 3 judges instead of jury would not undermine the defendant's right to a fair trial by an independent and impartial court, and the judges will deliver the reasons for the verdicts to ensure open justice. On closed-door trial, Article 41(4) of the National Security Law clearly stipulates that the trial shall be conducted in an open court. When circumstances arise, such as the trial involving state secrets and public order, all or part of the trial will be closed to the media and the public, but the judgment will still be delivered in an open court. Indeed, it is stipulated in ICCPR Article 14(1) that the press and the public may be excluded from all or part of a trial for reasons of inter alia, public order public, or national security. But any judgment rendered in a criminal case or in a suit of law shall be made public. Mr. Gomez also inquired about specific cases with lawyers as defendants. While it is not appropriate for us to comment on specific cases in this context, I should nevertheless reiterate that any law enforcement actions taken by Hong Kong Law Enforcement Agency are based on evidence, strictly accordance with the law for the acts of the persons or entity concerned, and have nothing to do with their background or occupation. While lawyers acting professionally are pivotal to our legal system, they are not treated any differently should they be brought before the law. Therefore, it is only natural that if a lawyer violates the law, he or she should face the same legal consequences as others. Regarding the arrangement under Article 47 National Security Law for the court to obtain certificate from the chief executive to certify whether an act involving national security and whether certain evidence obtained involves state secrets, we wish to point out that in all places around the world, be they unitary state or federal states, safeguarding national security, with the protection of state secret being an important and essential element, as a matter within the purview of the central authorities. According to Article 11 of the National Security Law, the chief executive shall be accountable to the Central People's Government for affairs relating to safeguarding national security in the Hong Kong SAR. The Committee for Safeguarding National Security, which the chief executive chairs, is vested with the important national security related functions under Article 14 of the National Security Law. Therefore, the chief executive is best placed to issue the certificate. the issue of judicial independence does not come into play. I should also stress that in a criminal case involving state secrets, apart from the certificate in question, the burden remains on the prosecution to establish all elements of the offense, including the person's knowledge that the information in question is state secret. Hence, a reasonable balance has already been struck between protection of state secret and the defendant's right to fair trial. Now, I will move on to follow-up questions raised by Mr. Furuya regarding the use of power by the police provided under Article 43 of the National Security Law. I wish to make 3 points. Firstly, endangering national security is a serious crime and sufficient power should be granted to the police to carry out the duties and responsibility in safeguarding national security. Point 2, during the enactment of the Article 43 of the National Security Law, due consideration was given to striking an appropriate balance between granting the necessary power to the police for the effective law enforcement. The police shall implement the measures stipulated in Article 43 of the National Security Law strictly in accordance with the law. As we have mentioned in para 38 of our replies to the list of issues, any action taken by the police under the implementation rules may be challenged by way of judicial review, including any claims that they are inconsistent with human rights. Members of the public may also lodge complaints against the police with the Complaint Against Police Office, with the investigation of such complaints under the supervision of the Independent Police Council. Lastly, I will wish to point out that as a matter of fact, the court have already adjudicated on a number of legal challenges made against search warrants and production orders issued respectively under Schedule 1 and Schedule 7 of the implementation rules, and also against freezing notices issued under Schedule 3. In each of these cases, the court have reviewed all evidence adjudicated in accordance with the applicable law in an impartial manner. Last but not least, I will wish to respond to 2 follow-up questions raised by Ms. Sansin. Ms. Sansin quoted comments made by the court in a case which concerns the issue of bail under Article 42 of the National Security Law, pointing to the issue of compatibility of the National Security Law vis-a-vis the ICCPR. This is actually the case which I just mentioned when speaking on the issue of bail arrangement. I should just point out that in the case, the Court of Final Appeal has helpfully pointed to how the human rights protection should work in safeguarding national security, emphasizing that it is not to say that human rights freedoms and rule of law are incompatible. Contrary, Article 4 and Article 5 of the National Security Law expressly stipulate that those rights, freedoms, and values are to be protected and adhered to in applying the national security law. The court also concludes that the article in question, that is Article 42.2, is to be construed and applied with the guarantees of human rights and the rule of law values affirmed by Article 4 and Article 5 of the National Security Law, as well as the general procedures rules made by Article 41 and 42 of the law, read as a coherent whole. Therefore, there's no question of incompatibility between the National Security Law and the ICCPR. As regards Ms. Sansin's observation on the possible overlap between the interception and covert surveillance ordinance regime and the regime under Article 43 of the National Security Law for the authorization of interception and covert surveillance operation, I will wish to make a few points. It should be pointed out that existing statutory mechanisms under the ICSO are not suitable for handling national security cases because such cases involve highly sensitive information and materials. For the effective enforcement of the law, the setting up of an executive mechanism headed by the chief executive is necessary to enable police to investigate into offenses endangering national security and protect national security via interception of communications and covert surveillance, while ensuring no leakage of highly confidential information pertaining to national security. Moreover, the executive authorities are in the best position in making assessment on national security risks that justify the use of such surveillance method. The type of cases which Schedule 6 of the implementation rules seeks to handle is by their nature much more serious than those under the ICSO. In particular, the purpose sought to be furthered by conducting interception COVID surveillance shall be that of preventing or detecting offenses against national security or protecting national security. It should be emphasized that there are stringent conditions to be met in the authorization of such covert actions, including the authorizing body has to be satisfied that the covert operation can meet the proportionality and necessity tests concerned before granting the authorization. And the police have to ensure legal professional privilege protection during the implementation of the authorization and be mindful of possible inaccuracy of information. Therefore, the regime provides various safeguards to interests such as private life, privacy, and personal data, and legal professional privilege as well. Thank you.
Mr. Mui, please.
Thank you, Madam Chair. I would like to respond to two comments made on last Friday. In response to the comments on judicial independence by Mr. Gomez made at the meeting last Friday, I would like to make the remark that the judiciary of Hong Kong is committed to upholding the rule of law and judicial independence in Hong Kong guaranteed under the Basic Law. All judges and judicial officers will no doubt continue to abide by the judicial oath and administer justice in full accordance with the law without fear or favor, self-interest or deceit. This commitment is wholly unaffected by the recent departure of the two non-permanent judges in the Court of Final Appeal. There are currently 4 local non-permanent judges and 10 non-permanent judges from other common law jurisdictions in the Court of Final Appeal. The judiciary will continue to identify suitable candidates for appointment as non-permanent judges, having regard to the operational needs of the Court of Final Appeal and turnover of non-permanent judges due to retirement or resignation. Secondly, I would like to respond to Mr. Buchan's request for information on Hong Kong court cases concerning the nature of the prohibition against torture and cruel, inhumane, or degrading treatment or punishment, collectively known as CIDTP, under Article 3 of the Hong Kong Bill of Rights, which implements Article 7 of the ICCPR. In the leading case of Ubermarker versus Secretary for Security, decided in 2012, the Court of Final Appeal expressly recognized the absolute nature of the protection against torture and CIDTP, which represented an internationally accepted standard, and held that this right is non-derogable, even in the extreme situation of a public emergency, which threatens the life of the nation by virtue of Section 5 of the Hong Kong Bill of Rights Ordinance, implementing Article 4 of the ICCPR with reference to the Human Rights Committee's General Comment number 24. These principles remain good law and continue to be followed by all levels of courts. The Hong Kong courts will construe local laws consistently with this principle. Thank you. I will pass the floor to Ms. Kathy Lee to comment on the other issues.
Thank you. First of all, let me explain the criteria for Privacy Commissioner for personal data to issue cessation notices as raised by Ms. Sassin last Friday. With the enactment of the Personal Data Privacy Amendment Ordinance 2021, the new regulatory regime empowered the Privacy Commissioner to serve a cessation notice to request the removal of doxing messages if the Commissioner has reasonable grounds to believe that, first, there has been an unlawful disclosure of personal data of a data subject without consent. Second, the disclosure has an intent or is being reckless as to the causing of any specified harm to the data subject or any family member of the data subject by that disclosure. And third, the data subject is a Hong Kong resident or is present in Hong Kong when the disclosure is made. For the first two criteria, they are the essential elements. i.e. actus reus and mens rea of crime for the new doxing offense. It is clear that the criteria for the commissioner to send out a cessation notice are clearly set out in the applicable law. The legislative intent for empowering the commissioner to issue a cessation notice is to remove doxing messages from, say, the social media platforms. In the words of the Honorable Mr. Justice Russell Coleman of the Court of First Instance, the impact of doxing on victims is severe and long-lasting. It is important, therefore, to remove doxing messages expeditiously, as they may be forwarded or reposted in seconds by netizens. It is noteworthy that an appeal mechanism is available for any person on whom a cessation notice is served and any other person who is affected by the notice. They may lodge an appeal to the Administrative Appeals Board within 14 days after the date on which a cessation notice is served. Finally, I would like to point out that the ordinance has already achieved a reasonable balance between protection of privacy and freedom of speech, and that the general public's basic rights and freedom, as enshrined under the Basic Law and the Hong Kong Bill of Rights Ordinance, including freedom of speech, flow of information, lawful news activities, etc., remain intact. Regarding Ms. Sassing's question on Leave Home Safe app, the Leave Home Safe app does not require registration of any personal information, nor have any tracking function. The app only captures the venue check-in, check-out date and time, and all these visit records are encrypted and stored within the mobile app inside the mobile phone of the users. These visit records would not be transferred outside the mobile app to any government system without the official request of the Center for Health Protection and the explicit consent and action of the users. The visit records will be automatically erased after 31 days. And only in the unfortunate event that the user got infected, would the visit records be required under the Prevention and Control of Disease Disclosure of Information Regulation to be uploaded, together with other relevant personal data of the user, example name and telephone number, to facilitate the Center for Health Protection in the epidemiological investigations and close contact tracing. The mobile app would issue exposure notifications to alert users who had visited the same venue with COVID-19 infected persons at around the same time. All the comparison and exposure notification processes are performed within the mobile app with no personal data involved. The comparison result and exposure notification would not be transferred outside the mobile app. Thank you.
Madam Chairperson, that's the end of our responses. Thank you.
Thank you, Mr. Tsang, to you and to the members of your delegation for the responses and for keeping the time. We will turn directly now to the last part of the list of issues, namely 20 to 27. So my colleagues will be asking questions on these issues. The first speaker on my list is Ms. Abdurrashol, and of course I will remind colleagues that they need to keep their time. Madam.
Thank you very much indeed, Madam Chair. Warm greetings to the delegation. Given the time constraints, I will go directly to the issues 19, 20, and 21 on freedom of expression. The committee takes note of the state's statement in the list of issues that the Hong Kong government is firmly committed to protecting and respecting freedom of the press, which is a fundamental right guaranteed by the Basic Law. Notwithstanding this statement, it is of concern to the committee that there are legislation and measures that in practice drastically curtail freedom of expression, contravening not only the rights guaranteed by the Basic Law, the Bill of Rights Ordinance, but also by the International Covenant on Civil and Political Rights. In fact, the committee has been informed that with the coming into force of the National Security Law 2020, Hong Kong has applied criminal sanctions against journalists who take a critical stance on aspects of police or government policy, including one particular journalist aged 73. More than a dozen journalists are currently in jail awaiting trial for publishing articles, and some face life imprisonment. Many have been detained under the NSL or for sedition, often being held on remand without bail. Another important issue relates to actions taken against media outlets, specifically against the Apple Daily newspaper and the digital media outlet Stand News in 2021. Of concern is the retroactive nature of the implementation of the national security law, as media outlets have been sanctioned even for content prior to the promulgation of that law. The committee has also been informed that in 2021, the state interfered in the public broadcast of Radio Television Hong Kong by increasing control and censorship and introducing new editorial guidelines which affected the direct ownership of two private media outlets. Similarly, several administrative changes introduced by the Hong Kong government have infringed on press freedom, preventing journalists from accessing public records and restricting access to information. Moreover, while Hong Kong had traditionally enjoyed a free and open internet prior to the introduction of the NSL, internet censorship is becoming increasingly prevalent. There are many denounced acts against freedom of the press, and it would be impossible to recount them because of the time. However, I would like to just give some data. Since the entry into force of the NSL in July 2020, journalists deprived of their liberty, over 12. Media outlets closed, 13. Media executives deprived of their liberty, 6. Raids on media outlets, 3. Twice on Apple Daily and once on Stand News. Journalists who've been victims of police violence, 13. The committee has received information that the Hong Kong Journalists Association filed a judicial review against the police for failing to facilitate and in certain cases actively obstructing lawful journalistic activities in violation of Articles 27 and 28 of the Basic Law and Articles 3 and 16 of the Hong Kong Bill of Rights, as well as Article 19 of the Covenant. There is evidence of police violence with mistreatment, including detention, verbal abuse, rubber bullet shootings, beatings, use of tear gas, and so on. And the figures speak for themselves. We have seen that there are 8 online media outlets whose signals were blocked at the time. There have been 1,115 journalists who have lost their jobs for broadcasting opinions. This is equivalent to 20% of Chinese media personnel. The media outlets whose funds were frozen, 2, Apple Daily and Stand News. Media outlets voluntarily shut down out of fear of reprisals, 7. We have also received complaints about sanctioned programs and journalists, as well as about the refusal or delay in the issuance of visas for foreign media journalists. In view of all these facts and figures, the following questions arise. Taking into account its incompatibility with international law and obligations under the International Covenant on Civil and Political Rights, is the state considering repealing the national security law? Are there any plans to amend or repeal the sedition provision of the Crimes Ordinance? Also, are there any plans to stop the introduction of new legislation that would further restrict freedom of the press and, in return, to amend existing legislation criminalizing online free speech for employees of technology companies, or that which allows the blocking of websites or messaging platforms? Could the delegation provide information on the draft fake news regulation? What would be the punitive force there? Does Hong Kong consider ending all criminal detention and immediately and unconditionally releasing journalists, as well as all people of Hong Kong detained for exercising their rights of freedom of expression? Similarly, is the state considering lifting the administrative measures which restrict the capacity and operations of the media? Does the state plan to restore the editorial independence of Hong Kong Radio Television? And as regards academic independence, in its responses to the list of issues, the government of Hong Kong affirmed that it attaches great importance to the freedom of academic defense and institutional autonomy. This notwithstanding, in 2021, the Public Policy Institute lowered Hong Kong's classification from C to D in its index of academic freedom, which is indicative of the significant decline over recent years. In July 2020, the University of Hong Kong sacked the professor of law, Benny Tai, together with the 47 people who were accused of subversion. He was convicted to 10 months of prison. In June 2021, the University of Lingnan sacked Deputy Professor Ip Lam Chong. It was said that he was on a blacklist of academics. In September, the University of Yingnan also fired the professors of cultural studies, Hui Po-kweng and Lo Wing-sang. In May, Hui Po-kweng was also detained under the framework of the national security law when he was at the airport going to take up an academic post in Europe.
Alan O,
a professor in the journalism department of the China University of Hong Kong and a specialist in censorship and self-censorship in the media, was also detained, charged with sedition. By the same token, in August of 2021, the Union of Professional Persons of Hong Kong, which is a body which brings together 95 members, announced that it was dissolving as an institution due to the enormous pressure it had come under as a result of attacks within the media, particularly editorials that had been written in the People's Daily and Xinhua newspapers. If I may turn now to the repression and crackdown on students' unions. On the 20th of February 2021, the University of Hong Kong imposed various punitive measures, including the withdrawal of financial and administrative support on the students' union in response to a document that had been issued which they had published criticizing the national security law. In October of 2021, the Students' Union was formally dissolved following actions and intimidation of the university, including death threats received by the Students' Union. In April of 2021, the administrators of the University of Hong Kong imposed sanctions on the Student Union, including the withdrawal of economic support. This took place after the Students' Union wrote an open letter to the Chancellor of the university in which it voiced its concern in light of the recent decision that there would be obligatory and compulsory classes on national security, which, according to the Students' Union, was representative of a crisis of institutional independence. The police detained 4 former members of the Students' Union on the charges of support or apologizing for terrorism, or supporting terrorism, or finding excuses for terrorism, and they did that under the NSL, the National Security Law. In February of 2022, the Students' Union of City University of Hong Kong received an expulsion order and were ordered to quit the university facilities within a week. They organized a farewell ceremony in which they wrote phrases on walls and on papers such as freedom of thought and academic independence, this on the external wall of a student shop which provided food and goods for the students. On February 2022, the National Security Police announced an investigation into the Students' Union for an alleged infraction of the NSL. They've also been made aware that the Department for Social Services and for Leisure, which is responsible for running public libraries in Hong Kong, ordered the withdrawal of books following the promulgation of the National Security Law. Can I ask the delegation of Hong Kong SAR, can the government share with us the complete list of books that were withdrawn from public libraries? Does Hong Kong envisage taking actions to restore freedom of thought and expression in the academic sphere? And is Hong Kong considering withdrawing all of the charges that's aforementioned and releasing all the academic students and other persons who've been arbitrarily detained for freely exercising their academic, artistic, or cultural expression? Thank you very much.
Thank you very much, Ms. Abdurrashol. The next speaker on my list is Mr. Furuya. Mr. Furuya.
Thank you, Madam Chairperson. Good afternoon to the members of the delegation in Hong Kong, and good morning to the members here in this room with us. Today, I will deal with paragraphs 23 and 24 together, since both are related to the right of peaceful assembly. I start with legal framework of the right of assembly in Hong Kong. According to Article 8 of the Public Order Ordinance, an organizer of meeting rather than certain sizes shall notice the intention to hold such a public meeting to the Commissioner of Police in writing at the latest a week before the day of planned meeting. Then under Article 9, the Commissioner may prohibit any public meeting notified where he reasonably considers such prohibition to be necessary in the interest of national security, public safety, public order, or the protection of the rights and freedom of others. The committee has a concern that the notification system under the Public Order Ordinance substantially works as an authorization system. In relation to this concern, please provide information on the number of the notification submitted by public meeting organizers and prohibited meetings among them over the last 5 years. According to the Article 16 of the Public Order Ordinance, if the on public meetings and processions, please indicate to what extent the appeal board actually works to oversee whether the commissioner's decision is compatible with the protection of peaceful assembly under the Basic Law and the Bill of Rights Ordinance, as well as Article 21 of the Covenant, including the number of appeals the board has received and the cases where it reversed the prohibition decided by commissioners over the last 5 years. According to the reply, the police arrested 15 persons in connection with the unauthorized assemblies that occurred on 18th and 31st August and 1st and 20th October in 2019. All of them are charged with offenses as organizing an unauthorized assembly or knowingly taking part in an unauthorized public assembly. However, General Comment 37 points out that a failure to notify the authority of an upcoming assembly does not render the act of participation in the assembly unlawful and must not in itself be used as a basis for arresting a participant or organizers or imposition of undue sanctions, such as charging them with criminal offenses. Please provide information on the number of arrests and prosecutions in relation to the public assemblies and processions over the last 5 years, and explain how the arrest of those persons who organized and participated in authorized assembly under the Public Order Ordinance is compatible with the right of peaceful assembly protected under Article 21 of the Covenant. On 4th October 2019, Chief Executive invoked the Emergency Regulations Ordinance to adopt the prohibition of face covering regulation, which imposed an almost total ban on mask wearing at public assemblies. Further, the Court of Final Appeal ruled that the ban was not unlawful in response to a judicial review challenging the adoption of the regulation. However, General Comment 37 clearly mentions that the wearing of face coverings or other disguises by assembly participant may form part of an expressive element of a peaceful assembly, serve to counter reprisal or to protect privacy. Please explain how the Hong Kong government considered the implementation of regulation is compatible with the right of peaceful assembly under the covenant, which also guarantees the anonymity of participants. Finally, the committee received the allegation that the Hong Kong government invokes a Prevention and Control of Disease Ordinance and other public health emergency laws in response to COVID-19 to substantially impose undue restrictions on the right of peaceful assembly. For example, in last March, participants in a 3-person protest in support of Ukraine were arrested and imposed a fine by officers for breaking the anti-pandemic measures. Please explain how the Hong Kong government makes the anti-pandemic restrictive measures compatible with right of peace assembly, particularly whether and to what extent the government has taken into account the necessity and proportionality of such measures for restricting the right of peaceful assembly on the ground of public health. Madam Chairperson, this ends my question. I'm looking for the fruitful dialogue with the State Party. Thank you very much indeed.
Thank you very much, Mr. Furuya. The next speaker on my list is Mr. Vulcan. You have the floor, sir.
Thank you, Madam Chair, and good morning to colleagues and greetings to the delegation in Hong Kong. I will turn immediately to issue number 25, which also deals with freedom of assembly. Regarding the demonstrations of 2019 to 2020, both the reply and in your answers last Friday, it was asserted that the police were acting to preserve order in the face of violent crowds. Allow me first to note very briefly that the jurisprudence under Article 21 of the Covenant establishes that violence by some cannot taint an entire assembly. In policing an assembly, law enforcement should strive to de-escalate as far as possible, and for an assembly to lose its protection, violence must be widespread. However, despite the official narrative, it has been credibly documented that the response of the Hong Kong police force to the public assemblies was, as described by one international NGO, reckless and indiscriminate. These assessments are based on live video footage and personal accounts of what transpired. Common complaints involve incidents such as excessive and indiscriminate use of force against unarmed protesters, including kicking them, beating them with batons, even on their heads, tackling persons to the ground, including pregnant women. The indiscriminate use of less lethal weapons, the use of contaminated water in water cannons, intimidatory tactics such as mass arrests, strip searches, and even sexual assaults, and the denial of access to medical treatment of persons arrested and detained. In light of these reports, if, as it is claimed, no deaths were caused by law enforcement, as you said on Friday, what accounts for the so-called suicides that occurred during these protests? Have any of those so-called suicides been investigated? And if so, please indicate where the results can be found. What medical facilities were made available for persons arrested and detained? And where is such information available for verification? Kindly explain why, out of more than 2,000 complaints lodged against the police in relation to these protests, only a fraction has been reviewed to date. Does the Hong Kong government intend to address the remainder, and is there a timeline for doing so? Were any individual police officers found liable for having caused injuries in the context of these assemblies? And if so, how many? If no criminal charges were brought, was any police subject to disciplinary action? Was the use of force by law enforcement recorded promptly in a transparent report, as required under the Covenant and explained in General Comment 37? If so, are those records publicly and transparently available? Given the claims that it was the protesters who were violent, please provide us with the statistics of the number of persons who were arrested, charged, and convicted in respect of the 2019 protests, and kindly describe the acts for which they were convicted. Where trials have not been concluded, are those defendants on bail? How many cases are pending? A recent court trial revealed that while dispersing crowds with tear gas on 18th of November 2019, the police provoked a stampede, in the course of which many people fell on top of each other, many were hospitalized, including some who were unconscious. In light of these and other allegations against your assertion that the police were accountable for the use of force, please advise whether the Hong Kong government will conduct a commission of inquiry into the entirety of what occurred in 2019 and 2020 to ascertain what happened and ensure accountability for the excessive use of force. And finally, on this issue, will the Hong Kong government conduct training of law enforcement in order to enhance their capacity to manage and control large-scale assemblies? I turn now to issue number 27, which deals with political participation. Following the last periodic review, the committee asked about the timeline for introducing universal suffrage in line with your obligations under Article 25 of the Covenant. Since then, instead of progress towards implementation, the rights of residents of Hong Kong have gone in the opposite direction. Some of the key changes involve, first of all, of the LegCo's 90 seats, only 20 are elected directly by eligible voters. The remainder are chosen by special constituencies, with the election committee choosing double that number of 40 legislators. In other words, while the 1,500-member election committee elects 40 legislators, 4.5 million eligible voters in Hong Kong only choose half of that. Second, the election committee is instrumental in choosing the legislators, but it is not a representative body. Its membership is determined by special interests who are all closely aligned to the Central People's Government. Third, even this reduced number of 20 seats is not freely chosen because of a new nomination threshold that requires nominations by at least 2 members from each of the 5 sectors of the Elections Committee, and partly because candidates have to be pre-screened by the Candidate Eligibility Review Commission, which can and has disqualified candidates for election. Fourth, the general public has no say in the election of the chief executive, despite provisions of the basic law which say otherwise. Rather, the chief executive is selected by the elections committee and then formally appointed by central government. The bottom line is that 4.5 million voters in Hong Kong can elect only 20 out of 90 legislators. The remainder, along with the chief executive, are chosen by a tiny, unrepresentative body which is dominated by special interests and is appointed by the government. This situation is completely irreconcilable with the requirements of Article 25 of the Covenant and the right of persons thereunder to vote and stand for elections. In light of these provisions, please indicate when universal suffrage will be introduced to ensure that the millions of Hong Kong residents are no longer disenfranchised and are able to vote and stand for elections to both the chief executive and the LegCo without unreasonable limitations. Please tell us what exactly is the obstacle to fulfilling one of the most fundamental rights in the Covenant of voting and participating in political life. Second, regarding the disqualification of candidates and legislators, please clarify the requirement that public officials must take their oath sincerely and solemnly, which is an open-ended standard that confers enormous discretion on the Commission. Please justify how the previous disqualifications of electors for their peaceful political beliefs is compatible with the Covenant, which guarantees both the right to political participation and the right to non-discrimination on the ground of political beliefs. Finally, please inform the committee whether the Hong Kong government intends to respect the letter and spirit of the Basic Law, which is meant to ensure the autonomy of Hong Kong and allow its residents to govern themselves, as reflected in Articles 18, 45, and the principle of non-interference in Article 22. Thank you very much to the delegation, and I look forward to your replies.
Thank you very much, Mr. Bulkan. The final speaker on my list is Mr. Gomez. Go ahead.
Gracias.
Thank you very much, Chair. And good morning to all colleagues, as well as a good afternoon. Greetings to the members of the delegation who have joined us from Hong Kong. I will refer to a single question, and that's question 26, and the issues it addresses, and these issues related to freedom of association. In the less than 2 years since the national security law was enacted, at least nearly 100 civil society organizations operating in Hong Kong have had either to disband or to relocate. According to Amnesty International, civil society organizations have reported facing increasing difficulties in carrying out their day-to-day activities. Could the delegation therefore provide information on steps taken to ensure that the enforcement of the national security law, as well as the enforcement of the society's ordinance, do not violate the exercise of the right of association in the light of the standards enshrined in our covenant, standards which require that restrictions on grounds of national security must be necessary and proportionate. The committee is furthermore concerned about reports received stating that the environment for civil society groups is especially hostile when it comes to trade unions that have international connections. The definition of foreign collusion contained in the national security law is broad. So is the definition of foreign agent under the implementation rules of said national security law. And all of this subjects persons suspected of fulfilling one of these categories to unjustified information requests from the government, which is sent to trade unions and other civil society groups. Trade unions were scrutinized by the Registrar of Trade Unions and the National Security Police. And they were particularly scrutinized in light of their relations with international trade unions, as well as being kept under close scrutiny with regard to access to international funding resources. They were threatened with deregistration or with potential criminal charges. Could the delegation respond to these concerns? Could I now ask the delegation to provide additional information on the following points? Firstly, the decision of the registrar to refuse registration to a civil society organization or a trade union can be appealed to the chief executive, according to information that we received in your replies to our list of questions. But in said replies, Hong Kong, China states that there is no appeal to a judge on the merits of the decision to refuse registration. Can the delegation explain how it is possible that the denial of a basic human right, such as the right of association, which is duly recognized in Article 27 of the Basic Law of the Hong Kong SAR, is not subject to judicial review? Secondly, could the delegation provide the committee with a list of those associations whose registration has been refused, and in particular, in a disaggregated manner, a list of those trade unions whose registration was denied or who have been banned? Thirdly, how many applications for associations registration are still pending? Fourth, can you explain what the impact of the national security law has been on the refusal of registration of associations? Fifth, since the enactment of the national security law, many trade unions have dissolved. At least 29 trade unions were disbanded in the first 8 months of 2021. A 2022 report by the International Labour Organization, the ILO, reported a severe decline in the respect for civil liberties and freedom of association in Hong Kong. The ILO also noted that the government of Hong Kong has refused the ILO's request for consultations on the application of the national security law. Can the delegation comment on this information? And finally, given that this committee has asked the government of Hong Kong, China twice whether civil society organizations would face criminal consequences for participating in the current ICCPR review, and given the fact that the delegation has not provided concrete answers to our questions along those lines, I would ask the delegation to inform the committee as to whether A, civil society organizations engaging with human rights or mechanisms of the United Nations will be regarded as engaging in acts of endangering national security under the society's ordinance. B, I would ask the delegation whether UN human rights bodies, including the OHCHR and treaty bodies, are considered foreign political organizations under the Society's ordinance. And C, I would ask the delegation whether such engagement by civil society organizations in the current ICCPR review will be criminalized under the guise of colluding with foreign forces within the definition of the national security law. Thank you very much for your kind attention, and I eagerly await your responses.
Thank you, Mr. Gomez. This concludes today's questions by my colleagues on the list of issues and issues 20 to 27. I now suggest that we suspend the meeting for 10 minutes in order to give the delegation the time to prepare its responses. So this meeting is suspended and will resume in 10 minutes from now. We are back, colleagues. Let me now turn the floor over to the delegation in Hong Kong for their replies. I will give the floor to His Excellency Mr. Cheng, and then he will order the responses of the of Hong Kong. So over to Mr. Cheng.
Thank you, Madam Chairperson. On Mr. Poken's questions about our improved electoral system, I would like to give a response first, and then after that, my colleagues will respond to other questions raised by members. First, I would like to stress that the development of democracy in Hong Kong SAR must be consistent with its constitutional order under the Constitution of the Basic Law and the Basic Law of the One Country, Two System principle. We also need to take into account the political, economic, social, cultural, and historical circumstances of Hong Kong SAR. In fact, democracy has taken a quantum leap forward in the Hong Kong SAR since its return to our motherland in 1997. The most recent development is the improvement of the electoral system. The new system has enhanced its democratic elements and quality. You may wish to note that the major improvements include expanding the election committee and the legislative council. The election committee is responsible for electing the chief executive and a major portion of our legislators. The election committee has expanded its membership from 1,200 to 1,500, and also the number of seats in the legislative council has increased from 70 to 90. The compositions of the election committee and the legislative council have been optimized to boost their representativeness. In particular, the election committee's composition is enriched with the addition of representatives of the small and medium-sized enterprises and grassroots organizations, etc. Legislative council members are now returned by the election committee, the functional groups in the functional constituencies, and district elections in the geographical constituencies. The two bodies have become more representative of Hong Kong society, allowing broader public participation and in political processes. In short, the improved electoral system and establish a democratic system that reflects the actual situation of Hong Kong corresponds to the requirements of implementing one country, two systems, and manifests Hong Kong's characteristics. The electoral system also put in place solid institutional safeguards to ensure full implementation of the principle of Petros administering Hong Kong. This also enhances the effective governance of the Hong Kong SAR, thereby achieving good governance for the public good and long-term stability and safety. All along, the Hong Kong SAR government has strived to ensure that our public elections are conducted in a fair, open, and honest manner. The successful implementation of the three important elections under the improved electoral systems demonstrates that broad representation, fair competition, political inclusiveness, and balanced participation. Please be rest assured that the ultimate aim of attaining universal suffrage in relation to Article 45 and Article 68 of the Basic Law remains unchanged. We strongly believe that improving the electoral system, ensuring Petros administering Hong Kong, and safeguarding the overall interests of society promotes the stable development of Hong Kong's democracy. Turning to the questions about the screening of candidates in public elections, I wish to point out that there is now a statutory candidate eligibility review committee. This committee aims to ensure that candidates in the election committee, chief executive, and legislative council elections comply with the requirements in Article 104 of the Basic Law. That means candidates would uphold the Basic Law and swear allegiance to the Hong Kong SAR of the People's Republic of China. This constitutional requirement is commonly found in most other jurisdictions for people aspiring to take up a public office. I must clarify that Petros administering Hong Kong is not to promote homogeneity in the politics of Hong Kong SAR, both in theory and practice. At a meeting celebrating the 25th anniversary of Hong Kong's return to the motherland and the inauguration ceremony of the sixth-term government of the Hong Kong SAR on 1st of July this year, President Xi Jinping made clear elaborations on this point in his speech. He said that Hong Kong residents, irrespective of their work, philosophy, occupation, or beliefs, can all contribute to the development of Hong Kong so as they love Hong Kong, genuinely supports the principle of one country, two systems, and observe the basic law of the Hong Kong SAR and the other laws of Hong Kong. His words are plain and explicit. As long as the person meets the requirements of Petros, he can participate in the elections in accordance with the law and serve the public by entering into the governance structure of the Hong Kong SAR, no matter they are pro-establishment or not. Madam Chairperson, Hong Kong has all along given due regard to the provisions of the ICCPR. At the same time, Hong Kong residents' right to vote and to stand for election are well enshrined in the basic law. These are guiding principles that we will continue to adhere and attach importance to. We will continue to ensure that the exercise of these rights is well protected under the improved electoral system and most of all, consistent with the provisions of the ICCPR applicable to Hong Kong SAR. And now my colleague, Shirley, Chris.
Thank you. Thank you, Madam Chair, and thank you to members for raising questions regarding to a number of issues under the Security Bureau. First of all, some members have raised questions about the freedom of assembly and freedom of association in Hong Kong. First of all, I'd like to stress that in Hong Kong, the freedom of assembly and procession, as well as the freedom of association, are fully protected by the Basic Law and the Hong Kong Bill of Rights. However, like any other jurisdictions, such freedoms are not absolute or unrestricted. Under Article 21 and 22 of the ICCPR, restrictions can be prescribed by law if it is necessary to protect national security or public safety, public order, protection of public health or morals, or the protection of the rights and freedom of others. One must observe the law in exercising his or her right of peaceful assembly. If there is any illegal or violent act, the police is duty-bound to take appropriate actions to restore public safety and public order. Court rulings have also highlighted that once a protest involves violence or the threat of using violence, the protest would have gone beyond the constitutionally granted bounds of peaceful demonstrations. It becomes an unlawful act which interferes with the rights and freedoms of others. The basic freedom conferred on Hong Kong residents are comprehensive and in no way lesser than the freedoms enjoyed by people of other advanced or free societies. The exercise of the rights conferred by law is by no means a reason or excuse for doing illegal or violent acts. This principle is universally applicable to Hong Kong SAR and likewise to different parts of the world. As confirmed by the Court of Appeal, the arrest and prosecution of persons who engage in unlawful conduct during demonstrations does not suppress or deprive their rights to demonstrations, assembly, or expression, as the law has never allowed such rights to be exercised by unlawful means in the first place. Some members have raised questions about the notification requirement. In fact, the notification requirement under the Public Order Ordinance has been upheld by the Hong Kong Court of Final Appeal as being constitutional. Such notification arrangement is required to enable the police to fulfill the positive duty resting on the government to take reasonable and appropriate measures to enable lawful demonstrations to take place peacefully. The police will need to strike a balance between facilitating the smooth conduct of peaceful assembly, and procession on one hand, while trying to minimize the impact on other members of the public. In fact, a legal requirement for notification is widespread in jurisdictions around the world. By law, the police may only prohibit or object a public meeting or public procession if it is necessary in the interest of national security, public safety, public order, or protection of the rights and freedom of others, and when those rights could not be met by the imposition of conditions. An independent appeal board is in place whose decision is also amenable to the challenge of judicial review. The allegation that the Hong Kong SL government is using social distancing measures under the COVID-19 to suppress lawful assemblies is simply unfounded and premised on mere speculations. Similar to many overseas jurisdictions, the Hong Kong government has put in place restrictions on group gatherings in public places so as to reduce the risk of spreading COVID-19 in the community, which poses serious threat to lives and health of the public. No political considerations have ever come into play, and it also meets the necessity and proportionality test. Over the past 2 years, the government has adjusted the social distancing measures, including restrictions in group gatherings from time to time, taking into account the latest developments of the pandemic. Some members have asked about the prohibition on face covering regulation, which aims to deter masked rioters from committing violent, illegal acts under hidden identity and to facilitate the police investigation. This measure was introduced in the light of the escalating violence of the mass protesters, which resulted in extensive and serious public danger at that time. While certain rights are affected by the prohibition being imposed, the Hong Kong Court of Final Appeal emphasized that the rights are not absolute and may be subject to lawful restrictions, including the interest of public safety, public order, and the protection of rights and freedom of others. The prevention and deterrent nature of that regulation was crucial, and the need to prevent the deterioration of peaceful gathering into violence is an integral part of the legitimate aim. When striking the balance between societal and individual interest, the interest of Hong Kong as a whole should be taken into account, since the rule of law itself was being undermined at that time by the escalating violence of masked lawbreakers who, with their identities concealed to evade responsibility, were posing grave danger to public safety. These restrictions are no more than reasonably necessary, and in fact, not unique to Hong Kong. Places like Canada, France, Germany, Austria, Spain, Sweden, Denmark, and Norway have similar laws. Regarding the Society's ordinance, the ordinance, which has been effective since 1940s, is compliant with the Hong Kong Bill of Rights, which was enacted to implement this ICCPR. An association would only be deregistered or prohibited if it is necessary in the interest of the national security or public safety, public order, or the protection of rights and freedom of others. Or if the society is a political body that has connection with a foreign political organization or political organization of Taiwan. A society which is aggrieved by the decision of the society's officer may appeal to the Chief Executive in Council, which may confirm, vary, or reverse the decision. The Chief Executive in Council's decision are amenable to judicial review. Organizations have the right to choose to dissolve, and we will not speculate or comment on the reasons for this disbandment of individual organizations. We'd like to stress that Hong Kong is a society that upholds the rule of law. Every person or organization must abide by the law. Our government has always handled matters, including the conduct and operation of local organizations, in strict accordance with the law. With regard to the police complaint system, as I mentioned at the hearing on Friday, the existing two-tier police complaint system is a fair, impartial, and effective arrangement which ensures that the public complaints against members of the police force are handled fairly and effectively. We believe that matters relating to the complaints against the police are best handled by the statutory independent Police Complaints Council,
which exercises independent oversight over handling of the complaints against the police and can make recommendations to the Chief Executive to improve the relevant police practices and procedures. In fact, the IPCC published in May 2020 a thematic study report, which sets out the IPCC's detailed, objective, and fact-based review on the large-scale events in 2019. A task force personally supervised by the Secretary for Security was established to effectively follow up the IPCC's recommendations, submitting regular progress report to the Chief Executive. In May 2022, after 2 years of dedicated work, the police has completed follow-up action on all the 52 recommendations by the IPCC, covering all major aspects of police work, ranging from training, strategy, and operational planning to public education and publicity. A total of 78 improvement measures have been introduced to strengthen police system and capabilities of individual officers. The police will continue to work with the IPCC to improve the police practice and procedures as necessary. Thank you. That concludes my response.
Afternoon, Madam Chair. As regards the use of force, I'd like to supplement some information. According to Section 10 of the Police Force Ordinance, the police have the responsibility to adopt lawful measures to maintain public safety, public order, as well as safeguard people's life and property. The police will, in light of the circumstances at the scene, make assessments and exercise professional judgment to take appropriate actions, including using the necessary force to ensure public safety and public order. And every newly recruited or serving police officer has to go through vigorous training on the use of force. The purpose of the training is to allow officers to fully understand how to use different levels of force in a safe and effective manner, including the use of verbal advice, verbal control, empty hand control, OC form, buttons, and firearms as a means to achieve the relevant lawful purpose. And police will exercise a high level of restraint at all times and cease to use force once the purpose is achieved. So relating to the allegation on the attacks on journalists, I would like to provide some information. The police has all along been respecting the rights of expression of views and the freedom of press. And the freedom of speech and press freedom have always been the core value of Hong Kong. The police uphold this core value and respect the monitoring role of the media. However, police actions will not be obstructed or hindered by anyone. We do not wish any conflicts between professional reporters and police, and hope that reporters at scene would cooperate and understand our concerns and operational needs. We will try our best to facilitate media work under the circumstances that no operational needs would be compromised. And during the 2019 social unrest, there have been several occasions where countless people wearing yellow vests standing in front of the police line. And it also came to our attention that some protesters pretended to be reporters by dressing in yellow vests, obstructing the police in executing their duties and even assaulting the police officers. No matter who commits the law, police will enforce the law fairly and impartially. In order to facilitate the professional reporters' work, the Hong Kong Police Force has established a cadre, namely the Force Media Liaison Cadre, since 2015. And because of the 2019 social unrest, we have substantially increased the size of the FMLC from 100 and something to over 300. Their roles mainly to facilitate media activities on the ground, engage the media and to handle issues arising from press activities, relieve frontline officers from media liaison office duty, and not to interrupt their operational role. Concerning the query on water cannons, well, in Hong Kong, we name it the specialized crowd management vehicles, which are commonly used by overseas law enforcement agencies, including the United Kingdom, France, Germany, Belgium, South Korea, to handle large-scale public assemblies in recent years. The purpose of deploying these vehicles at the SCMV, Specialized Crowd Management Vehicles, the SCMV, is to disperse protesters who stage violent charging acts at a distance in order to minimize direct confrontation with protesters. SCMVs can be equipped with pepper-based solution and or colored water, having regarded to operational needs in order to stop the violent and illegal acts. The effect of the pepper-based solution is similar to that of pepper spray, which causes people to have a short-term burning sensation of the skin and discomfort in the eyes. The discomfort will cease gradually if the persons leave the scene and rinse the affected body parts with plenty of water in a ventilated place. And the colorant used in SCMVs is the non-toxic coloring substance, which can assist police to identify violent protesters. The purpose of spraying colorant on the clothes and skin is to facilitate police in determining whether a person was at the scene of violent or unlawful assembly. It will not cause bodily harm or pose any risks to public health, and it can be cleaned by just using plenty of water. Also, there have been queries on a sexual assault by police officer. While the rapid development of information technology has brought convenience to the public, it also led to or aggravated invasions of personal privacy, disruptions to this social disorder, especially during the social unrest in 2019. The internet is not an unreal world that is beyond the law. However, fake news went viral through different social media in 2019. And some reports widely circulated online were later found to be unjust, groundless, malicious accusation against the police. I have mentioned it last Friday. I would like to reiterate again that a female alleged to have been raped inside a police station while she was in custody. Her allegation was found to be inconsistent with the evidence upon investigation. And also, there was a man alleged that number of rape cases committed by police officers inside the Sun Ok Leng holding center against the female protesters, which were also later found to be untrue. And this concerned person was arrested and prosecuted for misleading police officer. He was later subsequently convicted and sentenced to imprisonment. In any event, the Hong Kong SAR government pays close attention to rumors and fake news on the internet. And on finding any erroneous information circulating widely, we will take immediate actions to clarify through various channels. And also we reach out to overseas media and foreign government agencies concerned to clarify any unfounded information about Hong Kong circulating overseas. Finally, about the suicide case that has been raised by Mr. Volkan, that for all the suicide case that the police will conduct a thorough investigation, and those cases happened in 2019. In fact, some had already gone through the death inquest. So supplementary information will be provided at a later stage. I will pass the floor to my colleague.
Madam Chairman and members, just now members have raised various questions regarding the law enforcement action taken by the Hong Kong Law Enforcement Agency in respect of offences against national security on personnel or entities from a number of sectors, including the media, academic, labor organizations, civil societies, and others. A number of issues that was just raised. I have already explained them in quite detailed manner previously, including the handling of bail, the retrospectivity of the information on NSL information, and operations under Schedule 4 of the implementation rules, etc. And I will not waste time to repeat them here, but the explanation that I've given to members apply. I would wish, however, to highlight a few issues regarding law enforcement actions taken under the national security law and other relevant laws on national security matters, which applies to the various sectors that I've just mentioned. The Hong Kong government reaffirms the various freedoms as provided for under the basic law. The Article 4 of the National Security Law also stipulates clearly that human rights shall be respected and protected in safeguarding national security in Hong Kong. Actions taken by our law enforcement agencies will give due respect to the various international conventions. However, many rights and freedoms recognized in the ICCPR are not absolute and may be restricted for various reasons, including national security and or public order. And it applies to all countries or places, including Hong Kong. While we will not comment on any particular cases, we must emphasize that acts and activities that endanger national security may have very serious consequences, and actions must be taken to prevent and suppress such acts and activities. Any law enforcement actions taken by law enforcement agencies are based on evidence, strictly according to the law, for the acts of the persons or entity concerned, and have nothing to do with their political stance, background, or occupation. We must also point out that the national security law has clearly stipulated the 4 categories of offenses endangering national security, and these offenses are clearly defined and similar to those national security laws of other jurisdictions. The elements, penalties, mitigation factors, and other consequences of the offense are clearly prescribed. The courts having reviewed all evidence, will adjudicate each case in accordance with the applicable law and in a partial manner. Law-abiding people would not unwittingly violate the law. We note suggestions that just now that certain persons or organizations with certain background should be immune to legal sanctions for his or her or its illegal act and activities. It will be contrary to the rule of law to suggest that people or entities of certain sectors could be above the law. Turning to, while I will invite later on colleagues from the Education and Manpower Bureau and also the Labor Department to comment on this, on the academic freedom and also handling of labor unions. May I take a little time here to make special comments regarding 2 specific sectors, the media sector and the civil society. Since the city's return to the motherland, the Hong Kong government has been firmly committed to safeguarding the freedom of speech and the press, both of which are protected under the basic law as well as the Hong Kong Bill of Rights. In addition, Article 4 of the National Security Law also stipulates that the such rights and freedoms shall be protected in accordance with the law in safeguarding national security. However, these freedoms, freedom of the press and the speech, are not absolute and then can be restricted for reasons for protecting national security. As a matter of fact, the media landscape in Hong Kong is vibrant as ever, with a total of 209 media organizations, be they based locally in the mainland or overseas, are registered with the Hong Kong Special Administrative Region News and Media Information System of our Information Services Department at present. showing an increase after the implementation of the national security law. As always, the media can exercise their right to monitor the Hong Kong government's work, and the freedom of commenting or even criticizing government policy remains uninhibited as long as this is not in violation of the law. Members also asked about the issue of journalist visa. Whilst we will not, in particular on foreign journalists, while we will not comment on individual cases, we should point out that the Hong Kong government is firmly committed to protecting and respecting the freedom of the press, which is a fundamental right guaranteed by Article 27 of the Basic Law. The media reports freely in Hong Kong and performs its role as a watchdog over public affairs. Whether an individual application is approved or not is a matter of immigration control. It's irrelevant to the freedom of the press. As regards civil societies, I wish to make 2 points. There were comments that certain civil societies decided to leave Hong Kong after the implementation of the national security law. I should stress that decision of organizations, or be that individual as well, to remain or leave Hong Kong for whatever, anywhere for that matter, are based on different factors. Some people may consider leaving due to the violent protests and anarchy on the street by rioters during the 2019 serious violence. On the other hand, we should point out that the implementation of the national security law has actually reverted the chaotic situation and serious violence earlier, and restored stability and increased confidence in Hong Kong, thereby allowing the city to resume its normal operation and return to the path of development. One additional point, which was actually mentioned by Mr. Gomez, which I think is a follow-up to a point that I made in response to Mr. Balkan earlier follow-up questions, as to whether civil societies may, in the course of, as a result of the participation in the communication with the United Nations, may be subject to or have committed offense under the national security law. This I have also already explained clearly, that normal interaction and activities are already protected by the basic law and the laws of Hong Kong. And what Hong Kong's national security law seeks to punish, prevent, or suppress are distinctly different from normal interactions. As to the question raised by Mr. Gomez, whether a civil society having communication with the United Nations will fall under the definition of foreign political organizations under the society's ordinance, that would actually be depends on the facts and circumstances as well as the activities of each organization, and it is impossible for me to generalize here. One last point raised by Ms. Abu Rosha as to whether we would appeal the national security law. I have already highlighted just now the importance of the international national security law in reverting the chaotic situation. Hong Kong's institutional strength and core competency remain strong, and with the cessation of the violent protests, Hong Kong is moving to prosperity from now. But please assure, notwithstanding the importance and the important effect of the national security law that I've just mentioned, it will continue to be subject to Article 4 and Article 5, which make clear that safeguarding national security whilst safeguarding national security, human rights should be respected and protected. And also the principle of rule of law should be adhered to. That will not only be applicable to the application of national security law, but any laws relating to national security that we may enact in future. Now, may I give the time to colleagues from the Labor Department?
Thank you. Madam Chairperson, I would like to supplement our response on trade unions. Notwithstanding the enactment of the Hong Kong National Security Law, the legislative framework of the Hong Kong SAR, in particular the Trade Unions Ordinance on protecting the rights of employees to organize and take part in trade unions activities, has remained intact. There is no retrogression or infringement of the rights to freedom of association. As in the past, trade unions are free to affiliate with workers' organizations in foreign countries. During December 2019 to May 2020, the Registry of Trade Unions received over 4,000 applications for registration of trade unions. The great majority of these applications were formed for political purposes, with a view to winning seats of the election committee. Despite this, the Labor Department has deployed additional resources to process the application, and about 600 new unions were registered in the past 2 years. No application for registration of a trade union has been refused. In the event of refusal of a registration application, the applicant can appeal to the Court of First Instance against the decision of the Registrar of Trade Unions. Madam Chairperson, please rest assured that the Hong Kong SAR government will continue upholding the rights of employees to form trade unions and organize trade union activity to defend and promote their occupational interests. Thank you. I will pass the floor to my colleague, Esmond.
Madam Chair, Ms. Abdul Rashaw has made comments on academic freedom and student unions. Academic freedom is an important social value treasured by Hong Kong and is protected under Article 137 of the Basic Law. It is also a cornerstone of our higher education sector. We attach great importance to upholding academic freedom and institutional autonomy. All 8 publicly funded universities are statutory bodies. They have their own governing ordinance and statutes which set out their objectives, functions, and governance structures. The legislation provides them with the power and freedom to carry out these objectives and functions. Funding for publicly funded universities determined in accordance with the established mechanism. In particular, recurring grants are calculated based on their student number targets, and the funding required by universities for teaching and research purposes is rigorously calculated by the University Grants Committee. The university can then decide how to make the best use of resources. Neither the government nor the University Grants Committee specifies how they allocate and deploy their resources internally. Whilst universities enjoy academic freedom and institutional autonomy in various areas, this does not exempt them from public interest and criticism. In fact, in view of the significant funding that universities receive in the form of government subvention, as well as the importance of higher education to the overall development of society, it is understandable that the government and the community at large have a legitimate interest in the operations of universities. And universities are expected to remain committed to transparency and accountability in their operations with due regard to good governance. This is to ensure that the funding is put to appropriate uses that serve the best interests of the community and students. Last but not least, universities and student groups must abide by the law. The community also expects universities to uphold good governance and accountability to the public, and their operations have to comply with the law and meet the needs, the interests of students and the community at large. And funding for student groups is a matter for the universities to design under institutional autonomy. Madam Chair, that concludes my response.
Madam Chairperson, That's the end of our responses. Thank you.
Thank you very much to the delegation for all of its responses. I would ask now colleagues who wish to take the floor for any follow-up questions to make themselves known. The first speaker I have is Ms. Sansin. Madame.
Thank you very much, Madam Chairperson, and I would like to also greet the delegation both in Hong Kong, China, and here with us in the room. And I appreciate the replies that we received and also in the written form, some statistics that you shared with us. And I note with astonishment, I would have to say, that out of all the complaints received by the Equal Opportunities Commission, none of them resulted in a finding of any discriminatory act. So what I would like to ask is what standard of evidence the Equal Opportunities Commission uses when it is assessing complaints of discrimination under several ordinances. And also I would like to know how many of these complaints were submitted by LGBTI persons. I would also like to note that you have provided us with the statistics on complaints received by the Office of the Commissioner for Personal Data in the past 2 years, for which I thank you. And out of 6,707 complaints submitted in these 2 years, none of them have yet, it seems, resulted in any prosecution. So again, I would like to know whether perhaps you could provide us with some additional information on again, standards used for the assessment of these complaints, as it seems a very high number and no prosecutions, raises certain issues, how effective this mechanism is in practice. And finally, I have also asked last week about the reports that we have received on the Tai Tam Gap Correctional Institution that was turned into what is called a smart prison. Particularly, I was interested in concerns that the detainees are surveilled throughout their activities, including when they are in the showers and toilets. So could you please provide any response to these concerns expressed that the cameras are installed even in these most intimate places? Thank you very much.
Thank you very much, Ms. Sansin. Mr. Furuya.
Thank you, Madam Chairperson. First of all, I would like to thank the delegation for the very clear answer to the question I raised today. I have 2 follow-up questions on those answers. The delegation explained that taking into the interest of national security, public safety, public order, or protection of rights and freedom of others, the Commissioner of Police has prohibited the public meetings notified. In relation to this, the reply to the list of issues mentioned that police carefully considers various factors before making a professional assessment in order to decide whether a public meeting is prohibited or not. Please indicate what kind of factors have carefully been taken in account when the police prohibited or restricted the planned meetings. Particularly, please inform the committee whether the factors for assessment includes the content or purpose of meeting in question, like the demonstration against the government policy, or the assessment are content neutral. My second follow-up question is that the delegation explained that the regulation on mask ban was necessary in the context of stormy demonstrations in 2019 for the police to control those demonstrators and maintain public safety. However, if my understanding is correct, the regulation is still in operation at present. I wonder whether the comprehensive prohibition of wearing face coverings satisfies the necessity and proportionality test in light of the current situation of Hong Kong, which is more stable than in 2019. Please explain why the Hong Kong government still continues to prohibit assembly participants from wearing face covering at all. Thank you very much indeed.
Thank you very much, Mr. Furuya. I see also Mr. Gomez seeking the floor.
Thank you very much indeed, Madam Chair. I just wanted to ask a follow-up question of the delegation from Hong Kong, China, on the response that they gave to one of my questions. I asked whether the involvement of civil society organizations in this constructive dialogue might entail some harm, or whether their conduct might be classified as criminal conduct by the Hong Kong authorities. I also asked whether human rights bodies of the United Nations, including specifically the Office of the High Commissioner of the United Nations for Human Rights and treaty bodies, whether they are foreign political organizations as regards the ordinance governing such associations, and whether participation of these entities, of these treaty bodies, whether that would be classified as collusion with foreign forces in line with the national security law. The response that I got was that the national security law would not apply if the activity of these bodies is normal. But of course, the delegation of Hong Kong, China might take it that this is might understand that this is an excessively vague response, because the conduct of these organizations and these associations is described, I described it in my question. These are organizations which cooperate in terms of periodic reviews of states. These are bodies which oversee the compliance with international treaties, such as this committee. So my question then is whether we would be considered as political foreign organizations to the effect of applying the Ordinance of Associations. No, I think the response is that whether if we conduct ourselves normally, nothing would happen. I think that response is insufficient. I thank you.
Thank you, Mr. Gomez. Ms. Abdurrashol.
Many thanks indeed, Chair, and my thanks also go to the delegation for the replies they finished thus far. I've taken note of the fact that in response to my questions on freedom of expression, the point was made that when freedom of expression clashes with security considerations, freedom of expression can be restricted, but then it doesn't equate to freedom of expression in the understanding that we have of it. I don't believe that the criteria that would guarantee freedom of expression that provided for in our covenant are being upheld. I also didn't get a response to some of my questions. Some of the other responses were rather vague, I'm afraid. For example, the response to the draft bill on fake news, the question I asked thereon. And I'd welcome a more in-depth answer there too, or a proper answer there too. At this stage of the dialogue, I'd also like to ask for the list of books that have been banned in public libraries, because this caused a lot of unease in academic circles, given that many colleges and schools are already getting rid of books, and they're doing so because they're afraid of being accused, if they keep those books, of having breached national security under the national security law. I'd like to recall that freedom of expression is a right that underpins other rights and freedoms. So the government of Hong Kong must make superlative efforts to ensure that freedom of expression is up and freedom of speech are held. Thank you very much.
Thank you very much, Ms. Abdurrashol. And the final speaker I have on my list is Mr. Bulkan. Go ahead, sir.
Thank you, Chair, and thank you very much to the delegation for your answers. And in particular, I would like to thank you for the very clear and organized way in which you presented the information. I want to return to some of the questions I asked today and on Friday, and the information you gave me. Today you said that in terms of the complaints mechanism, it was best handled by the IPCC. However, I would like to point out that 5 overseas experts recruited by the IPCC itself stepped down from the panel, citing doubts as to the independence and capacity of the IPCC. And then a November 2020 court ruling actually confirmed that the current system is inadequate for investigating police violations. So I do want to explore, or if you could provide some explanation of why this is the only mechanism considered, given these concerns expressed by the experts hired by the IPCC as well as the court. That said, I note information that 52 of the recommendations made, 52 were implemented, and then 78 measures were introduced as a result. I note as well that this information is contained in the IPCC annual report of 2020 to 2021. However, permit me to note that the wording as to these recommendations and the implementation measures is quite vague in the report. So can you elaborate on what those recommendations precisely were as opposed to the themes? And what precise measures were implemented as a result of the recommendations? And in relation to the information provided, could you give us actually precise information as to the chemical substances used against protesters and not just tear gas? In particular, we'd like to know what is the chemical composition of the substances used and the manufacturing details, particularly in light of some of the information that we obtained that tear gas used was past the expiry date. Since we have the time, honorable members of the delegation, could I point out that I did not get answers to some of the questions I raised, for instance, around medical facilities for persons arrested and detained? Could you please explain, I will ask again, why out of more than 2,000 complaints lodged, the bulk have not been reviewed? And are any of the persons, well, is there a timeline for doing so? Could you also explain for us if any individual officers were held liable, and if not, why not? And finally, given these competing allegations, many from international organizations and civil society, of excessive violence, as opposed to your responses of that the protesters were violent, can you say whether the government would consider some overarching commission of inquiry that would investigate all of these competing allegations and then determine exactly what happened? On that score, permit me to remind you of the standards of the covenant, particularly as interpreted most recently by our General Comment 37, which talks about an individualized assessment of culpability. So in other words, not tainting an entire assembly because of the actions of just a few people. The allegations of civil society was that there was isolated violence, but in response, the police tainted the entire assembly. Furthermore, our general comment points out that the duty of the national authorities is actually to facilitate assemblies, and that the exception of national security actually raises a very high threshold. It's not just isolated violence, it's actually things dealing with the territorial integrity of the state or serious violence. And that, with respect, did not occur here. So if you could give us some more details about this and how this will be addressed, these competing allegations, I'd be very grateful. And finally, just on the subject of universal suffrage, I'm a bit puzzled by your response that actually the reforms represent improvements and that they are broader representation. Perhaps you could clarify this for me, because my understanding of the reforms was that even though the seats increased, actually less seats are now directly elected. So before it was 35 could be elected directly, now it's only 20. And as I pointed out, the elections committee, which is a 1,500 member body, elects the bulk of these seats, whereas 4.5 million voters in Hong Kong elect only 20. So that actually seems smaller both in absolute and relative terms. So, and then of course there's the pre-screening and the fact that people are now disqualified for their political views. So could you explain how can you describe this as broader? And ultimately, members of the delegation, I thank you for your commitment that for your assurance that the commitment to universal suffrage will be upheld. And I perhaps allow me to close by asking if you have a timeline for implementing this. So once again, thank you very much for your answers, and I look forward for any further information on these follow-up questions. Thank you, Madam Chair.
Thank you very much, Mr. Bulkin. I will give over the floor now to Mr. Tsang for perhaps some brief responses to some of the follow-up questions raised by my colleagues before we go to the closing statements. Mr. Tsang, over to you.
Thank you, Madam Chairman. It seems that most of the members' foreign questions are still about the national security law and the handling and complaint mechanisms of our police colleagues. Maybe I first invite Mr. Mui to give a response first.
Thank you, Mr. Zhang. Thank you, Madam Chair. I would like to take a few minutes to respond to a question raised by, as a follow-up question by Mr. Gomez in relation to the offense of collusion under the national security law. Our response is that the collusion offense under the NSL is actually a very serious offense. It is not easy for an ordinary person or an ordinary institution to commit the collusion offense under the NSL in the normal course of their life or business. To elaborate on my points, it is important to correctly understand the collusion offenses under Article 29 of the National Security Offense. Actually, it covers a number of different acts that may be caused by the collusion offenses. But if you consider the terms of the provision, which is Article 29, the collusion offense is an offense if a person steals, spies, obtains with payment, or unlawfully provides state secrets or intelligence concerning national security for a foreign country or an external element. It is also an offense if a person engages in activities such as requesting, conspiring with, receiving instructions, etc., from a foreign country or external element to commit certain specific types of acts, which are explicitly set out in Article 29. Those specific acts include, first, waging a war against China, using or threatening the use of force to seriously undermine the sovereignty, unification, and territorial integrity of China. Secondly, seriously disrupting the formulation and implementation of laws and policy of Hong Kong Special Administrative Region government, which is likely to cause serious consequences. Thirdly, rigging or undermining an election in Hong Kong, which is likely to cause serious consequences. Fourthly, imposing sanctions or blockage or engaging in other hostile activities against Hong Kong Special Administrative Region or China. And lastly, provoking by unlawful means hatred among Hong Kong residents towards the Central People's Government or the Hong Kong SAR government, which is likely to cause serious consequences. So it is clear that to any well-informed person when reading the terms of Article 29 of the National Security Law that it does not preclude any interaction or communication between a Hong Kong resident or a Hong Kong institution or enterprise with others or their counterparts overseas. The prohibition under Article 29 relates only to acts that would endanger national security, which are clearly set out. So to emphasize the points that I'm making, in the enactment of the National Security Law, the National People's Congress already make it clear under Article 4 of the National Security Law that in enforcing the laws under the National Security Law to protect national security, it is necessary and is a legal requirement to take into account protection of human rights. This is my response to the question on collusion offenses. I would like to pass the floor to my colleagues. Shirley, thank you.
Thank you. Thank you to members' questions. A member have asked about the smart prison in Tai Tam Gap. I'd like to highlight that in designing various smart prison projects and systems, the Correctional Services Department will protect the privacy of the persons in custody by following the strict requirements stipulated in the relevant laws and guidelines issued by the Office of the Privacy Commissioner for Personal Data. Regarding the toilet areas, it would be blurred in the system, and the blurred area is unrecoverable, so as to ensure the protection of the privacy of the persons in custody concerned. As regards the question about the face covering regulation, I've mentioned previously the rationale behind that regulation, and we will keep the situation in review and will review the legislation as and when appropriate. Regarding fake news, jurisdictions worldwide are facing problems of doxing, hate speech, discriminatory remarks, and false information into the internet and social media. This information not only confuses the public, but also divides the society, incites hatred, and compromises public order and even national security. We note that some overseas jurisdictions have introduced legislation to combat fake news in recent years. The laws of different places vary in terms of their legislative intent. Some jurisdiction adopts a comprehensive approach with a fake news specific legislation, while some jurisdictions focus on election-specific falsehoods or deception that intend to influence the electoral process. And some jurisdiction has a dedicated law to regulate unlawful content on social network. The Hong Kong SAR government is making reference to the experience of other countries and regions in tackling fake news with a view to working out a set of effective regulatory proposals appropriate to the local legislation, local situation. Proper public consultation will be conducted before putting forward any legislative proposals. Our members have also raised many specific questions and request statistics regarding the police complaint system. In the interest of time, that will be provided after the meeting today. Thank you. That concludes my response. I would like to pass the mic to Ms. Chow.
Thank you, Madam Chair. In response to the query on the consideration factors upon receipt of a notification of a public meeting, that actually Hong Kong residents enjoy the freedom and the right to peaceful assembly, procession, and demonstration under the Basic Law. However, in exercising such rights, they shall not willfully disrupt public order or in defiance of the law. The police have been handling all public order events in a fair, just, and impartial manner in accordance with the laws of Hong Kong. And the enforcement policy of the police is to endeavor to strike a balance or by striving to facilitate the smooth conduct of lawful and peaceful public meetings and processions on one hand, while on the other, minimizing the impact of such events on members of the public and other road users, as well as ensuring public order and public safety. The police have the statutory duty to maintain public safety and public order when a situation such as illegal blockade of roads, paralyzation of traffic, and unlawful assembly occurs that it seriously threatens public order and public safety. The police are legally bound to take appropriate actions to ensure public safety and public order. In handling public order events, the police will conduct holistic risk assessment based on the objectives, nature, number of participants, past experience, and the latest situation of individual events of manpower deployment and formulation of operational plans and contingencies. We will also deploy manpower flexibly and implement crowd management measures in light of the prevailing circumstances to ensure public safety and public order. Turning to the chemical components of the chemical irritants as raised by Mr. Balkan. In view of the operational consideration, it's not appropriate to disclose the detailed composition. Yet I have to reemphasize that the actually chemical irritants remains one of the most common riot control agents around the world by overseas law enforcement agencies, including the tear gas. Yet there was no expressed concern about the toxicological content of, say, tear gas, nor report about adverse consequences of its use in overseas jurisdiction, even when tear gas was applied in an enclosed area in a Western country in 2021. And also, the literature review, as I mentioned last Friday, that there is no indication that tear gas will present health issues or environmental problems. And that concludes my response. Thank you, Madam Chair.
Madam Chairperson, on Mr. Balkan's further inquiries about our electoral system, I think members would agree that every place has its own historical, cultural, and political background, and there is no cure-all in respect of electoral system and how it's be improved. It has to be dependent on the actual situations of that place, and the ultimate goal is to achieve good governance of the place and bring happiness to its people. And you can see that. I think that's how a good democratic system should be. So that's the end of our further responses. Thank you.
Thank you very much, Mr. Tsang, and I thank the delegation for all its responses, including to the follow-up questions raised by my colleagues. I will now again revert to you, sir, for your closing statement before I also close this session. So, Mr. Tsang, you have the floor for your closing statement.
Madam Chairperson, distinguished members, it's a great pleasure here to attend the Human Rights Committee's meeting on the Hong Kong SAR's fourth report in the light of the ICCPR. They give us the opportunity to present the developments made since the submission of the third report in 2011. The meetings also enable us to have a frank and constructive exchanges with members of the committee to dispel any doubts on Hong Kong SAR's human rights situation. Hong Kong has been a special administrative region of the People's Republic of China since 1997 and has been implementing the one country, two systems policy, which is underpinned by the Constitution of the People's Republic of China and the basic law of the Hong Kong SAR. The Hong Kong SAR mirrors in all significant institutions and policies the Hong Kong that existed before 1997. There has been continuity as well as significant progress. For instance, Hong Kong has continued to play its commercial, financial, and legal strengths. In 2021, Hong Kong was acknowledged as the world's freest economy by the Fraser Institute. Judicial independence remains solid and robust. Hong Kong's rule of law has been consistently recognized globally in the worldwide governance indicator project of the World Bank. Hong Kong has been consistently above the 90th percentile in the aggregate indicator in respect of the rule of the law, showing a remarkable improvement from 69.85 back in 1996. Human rights guaranteed constitutionally by both the Constitution of the People's Republic of China and the Basic Law of the Hong Kong SAR, and is underpinned by the rule of law and an independent judiciary. The provisions of the ICCPR as applied to Hong Kong SAR have already been incorporated into local law by the Hong Kong Bill of Rights Ordinance. Both the Central People's Government and the Hong Kong SAR governments are determined to make one country, two systems a continued success. However, events in the Hong Kong SAR in recent years, particularly the serious violence in 2019, posed challenges to the one country, two systems principle and endangered sovereignty, national security, and Hong Kong's stability. Against this background, the Standing Committee of the National People's Congress adopted the Law of the People's Republic of China on safeguarding national security in the Hong Kong SAR in June 2020. The Hong Kong National Security Law is vital in bringing Hong Kong SAR back on track and safeguarding our country's sovereignty, security, and development interests. In implementing the law, the legitimate rights and freedoms of Hong Kong people are protected and respected, as expressly provided for in the law. Our fundamental rights and freedoms remain intact under the Basic Law, which also provides, among others, that the provisions of the ICCPR as applied to Hong Kong SAR shall remain in force. As we have explained over these 3 days meetings, there is no cause for concerns that the legitimate rights and freedoms as well as the rule of law of the Hong Kong SAR are under threat after the adoption of the Hong Kong National Security Law. First of all, the National Security Law does not affect the common law system in Hong Kong. And secondly, the well-established criminal justice system is similarly applies to any national security offenses. Thirdly, judges remain independent and impartial while adjudicating cases strictly in accordance with the law and evidence and are free from any interference. Principles such as presumption of innocence and the right to defend oneself continue to be applied in cases concerning national security. To attain long-term stability, the National People's Congress, as the constitutional level, adopted the decision to improve the electoral system of the Hong Kong SAR. In so doing, the Central People's Government is faithfully exercising its overall jurisdiction over the Hong Kong SAR, fully supporting the Hong Kong SAR government to put things back on the right track and govern Hong Kong SAR in accordance with the law and protecting the well-being of over 7 million residents of the Hong Kong SAR. The overarching approach for improving the electoral system of the Hong Kong SAR is to enhance the balanced and orderly participation and ensure broader representation of the political structure through the reconstituted election committee. The new system, the election committee comprises 1,500 members from 5 sectors, thereby enhancing its representation. The number of seats in the Legislative Council is increased from 70 to 90, and all of them are returned by election, thereby upholding residents' right to vote and to stand for election. The election committee is composed of representatives from different sectors of Hong Kong community. Since it elects some of the legislators and nominates candidates for the Legislative Council elections, it helps go beyond the vested interests of specific sectors, districts, and groups and makes the Legislative Council more representative of the overall interests of Hong Kong. Moreover, as the election committee elects the chief executive and some legislators, this ensures that they share the same political belief, which is conducive to the effective communication between executive authorities and the legislature, as well as the implementation of executive-led governance structure as enshrined in the Basic Law. Through constructing a democratic system that is consistent with the actual situation of Hong Kong and fully conforms to the constitutional order under the one country, two systems principle and manifests Hong Kong characteristics, Hong Kong is now back on the right track. I trust Madam Chairperson and members will agree that every place has its own historical, cultural, and political background. There is no cure-all in respect of electoral system and improvements to be made. The Standing Committee of the National People's Congress, when deliberating and the amendments to the Annexes 1 and 2 to the Basic Law, has already taken into account the actual situation in Hong Kong. It should be looked at that the ultimate aim of universal suffrage to be achieved in light of actual situation of Hong Kong and in accordance with the principle of gradual and orderly process as specified in Article 45 and 68 of the Basic Law has never been changed. The United Nations Human Rights Committee can rest assured that the Hong Kong SAR government is firmly committed as ever to the protection of human rights and always seeks to make improvements suited to Hong Kong's realities. This is evident in, just to name a few, the introduction of the statutory paternity leave in 2015, the establishment of a Commission on Children in 2018 to formulate long-term targets and strategic directions concerning the holistic development and important growth stages of children, the enhancements of legal protection from discrimination and harassment under the 4 anti-discrimination ordinances in 2020 and 2021, the efforts to combat doxing acts through amendments to the Personal Data Privacy Ordinance in 2021, which has struck a fine balance between the protection of privacy and freedom of speech, and the improvements in handling of non-refoulement claims through amendment to the Immigration Ordinance in 2021. This year marks the 25th anniversary of the establishment of the Hong Kong SAR. Our anniversary theme is a new era, stability, prosperity, opportunity, to highlight the abundant opportunities of Hong Kong and the bright future ahead. Madam Chairperson, with order restored by the Hong Kong National Security Law and the electoral systems being improved, the Hong Kong SAR will turn over a new leaf and forge ahead with openness, diversity, and harmony under the successful and well-proven one country, two systems. Thank you.
Thank you very much to the head of delegation. Ladies and gentlemen, dear colleagues, the 4th periodic report submitted by Hong Kong, China under Article 40 of the Covenant provided an opportunity to engage in a frank and constructive dialogue on the framework of human rights enshrined under the Hong Kong Basic Law and Bill of Rights and the implementation of Hong Kong's obligations under the Covenant. The committee welcomes the report and the detailed replies on the progress achieved and the challenges faced during the reporting period, and the commitment repeated by the government of Hong Kong and the delegation, including in the closing statement by the head of delegation, to the protection of human rights and freedoms. At the same time, the committee has raised its concerns with regard precisely to the upholding of the rule of law and the protections afforded to the people of Hong Kong through the human rights guarantees, especially those protected under the ICCPR, mainly against the backdrop of the promulgation of the national security legislation in June 2020 conferring authority to the Hong Kong government to enact legislation bypassing local legislature, and the ensuing stringent measures and wide extraterritorial reach. Issues such as fair trial guarantees, independence of the judiciary, freedom of the press, freedom of association, assembly have been discussed, and the concerns have been raised by my colleagues and, of course, responded by the delegation. In a democratic society, freedom of speech, of expression, and participation, and pluralism generally should not be unduly restricted without taking into account the requirements of necessity, reasonableness, and proportionality as provided for under our covenant. This has been an opportunity for the party to engage with the committee, but also for civil society to make its voice and views heard. The committee, as expressed by many of my colleagues, expects that this engagement of civil society will not result in any adverse consequences. I once again thank the delegation for this constructive dialogue. I remind the delegation that it has 48 hours to send any additional or further information in writing to the committee. I wish a good evening to the delegation. No journey back. They're already in Hong Kong. No journey back. And this meeting is adjourned.